You ever get a bill from your homeowners association and just get that feeling like, wait a minute, is this right? Most of the time, it's a simple fix. But what if that one little question peeled back the layers on a mistake that had been going on for nearly 50 years? Well, today, we're going to dive into the incredible story of one homeowner's fight for exactly that.
It's a question a lot of us might wonder about, right? You live in a planned community, you figure the rules apply to everybody, especially the people who are supposed to be enforcing them. But what if they don't? I mean, think about that. For almost 5 decades, this association was operating in a way that went directly against its own rulebook. It took just one person, one persistent resident, to stand up and say, hey, wait a second, and challenge the way things had always been done.
So how did this all kick off? Well, it all started with a single complaint. Let's meet the key players at the center of this whole thing. Okay, so in one corner, you've got Greg Fish. He'd been a resident there since 2002. And in the other corner, you have the association's board. And the conflict? It sounds pretty simple on the surface. Mr. Fish was convinced that the way they were calculating his fees was just wrong. And the thing is, he had the documents to back it up. Now, before we go any further, you gotta understand what CC&Rs are. The easiest way to think about them is like the Constitution for the entire community. It's a legit, legally binding contract that lays out all the rules, including, and this is the important part, how money is supposed to be collected. This isn't just a friendly set of guidelines, it's the law of the land for that HOA.
And it's in that rulebook, in those CC&Rs, that we find the heart of the entire problem. There was a huge gap between what the official rules said and what the HOA was actually doing in real life.
And here it is, laid out plain as day. The CC&Rs couldn't have been clearer. Fees had to be prorated. You have a bigger condo, you pay a bigger share of the expenses. You have a smaller condo, you pay a smaller share. I mean, that makes sense, right? But what did the HOA do? For 46 years, they just took the total cost and split it evenly among every single homeowner. So, why?
So you have to wonder, how could a practice that so clearly broke their own rules just keep going for that long? Let's take a look at the HOA's side of the story.
And this right here? This is the official justification from the association. What they're basically saying is, way back in the day when the community first started, the money difference between the units was so small that they just kind of decided, it's not worth the trouble of doing the math correctly.
I mean, this timeline really puts it all into perspective. It all starts way back in 1968 over a measly 43-cent difference. Fast forward to the 70s, and we find out the guy who would later become the board president already knew about the prorated rule. Then in the 80s, he believed some outside agency was telling them to do it this way. But the bottom line is, the practice just kept rolling on, decade after decade, totally unchallenged, until Greg Fish finally spoke up in 2013.
So as you can imagine, Mr. Fish's complaint eventually led to a formal hearing. And this is where the whole story, all the details, finally started coming out under oath.
One of the most important people to speak was a guy named Michael Latz. He was the former community manager for the association, and his testimony turned out to be a really big deal. And there it is, the smoking gun, an admission from the guy who used to manage the place that the board knew. This wasn't just some forgotten rule or an honest mistake. According to his testimony, it was a conscious choice to keep doing something they knew was a direct violation of their own rulebook. Okay, but you might be thinking, so they broke a rule, but did it actually hurt anyone? Well, Greg Fish's property manager, Karen Jackson, showed up with the receipts, literally. She presented the numbers to show what this 46-year habit actually cost people. And get this, that tiny little 43-cent difference from 1968, it had snowballed. Because of the wrong billing method, Mr. Fish alone had been overcharged by almost $2,000. And that was just in the last 6 years. This was definitely not a trivial amount anymore.
So after hearing from everybody, the homeowner, the board president, the managers, the judge had all the information needed to make the final call.
And the verdict? It was completely decisive. Greg Fish, the homeowner who did nothing more than ask his association to follow its own rules, had won. And the judge's orders were super clear. Not only was Mr. Fish declared the winner, but the HOA was ordered to finally start following its own rules. On top of that, they had to pay back his filing fees and pay a penalty for the violation. It was a total and complete victory for him.
Okay, so why are we talking about this one little dispute in one condo complex in Arizona all these years later? Because honestly, the lessons from this case are for absolutely anyone who lives in or serves on an HOA board. So let's just break down the big takeaways here. Number 1, those CC&Rs, they're not suggestions. They are legally binding contracts. 2, that old excuse, but we've always done it this way? Yeah, that means absolutely nothing when you're up against the written rules. This case also proves that it just takes one person to hold an entire organization accountable. And finally, it's a perfect example of how what seems like a tiny little error can grow into a massive problem over time.
Which brings us to the final thought, really. This entire 46-year mess, ending in a whole legal battle, started because one person actually read the rules and asked a pretty simple question. And it kind of makes you wonder, doesn't it? Do you know what's in yours?